All right, so welcome everyone to the Privacy Exchange Committee Show and Tell series with our very special guest, Aaron Alva, who spent the last decade behind the scenes at the FTC as a technologist and tech advisor, shaping the future of privacy and security enforcement in the United States. So, leveraging his unique combination of technical skills and legal skills, Aaron helped revolutionize FTC remedies, moving beyond process-based programs to establish bright line prohibitions that protect sensitive health data, location information, browsing history, TV viewing data, which is a hot topic again, and so much more. So today we're going to spend the next 25-ish minutes together. Aaron and I will have a chat for about 10 to 15 minutes that will be recorded. And then we will turn off the recording and open it up to audience questions and answers for about 10 to 15 minutes. As a reminder, all of the information shared today is for general information purposes only and is not legal advice. So if you need legal advice, contact your own attorney with any respect to whatever you've got going on. I'm not a lawyer. Aaron's not your lawyer. Okay, so with that behind us, let's hop in. Aaron, my first question for you is, you spent a decade working at the FTC, as I mentioned. Can you tell us a little bit more about your role as their very first technical and legal advisor and what spurred the need for that role?
Sure. Yeah, I'm really excited to be here. You have such a supportive privacy community, Mary, so it's exciting to be here. So taking a step back, like the FTC's mission is to protect the public from unfair and deceptive business practices and anti-competitive behavior. And as like the federal enforcer for privacy, and many other of these practices, the FTC is responsible for essentially all of commerce in America, which is a very wide mission. So in like a tech-driven and tech-mediated ecosystem, it becomes all the more important for enforcers to understand the technology, how consumers interact with technology, consumers' expectations around how they interact with technology. And that helps inform enforcement actions in terms of what practices are unfair to individuals. So that's where I think the role of technologist comes in. I like to say that my role as a technologist was assisting attorneys on technical aspects of investigations, primarily security and privacy investigations. And then to add another layer, I'm also an attorney, and it's really been helpful to have both like my technical skill set as well as my legal skill set to help attorneys with understanding that translation between the technical facts, what to ask for, what to look for, what harms to evaluate, and the legal side, like what is the Section 5 of the FTC Act have to say about whether or not there's a case to have here or not. So that has been, I think, a very helpful and important combination for me to help the decision makers at the FTC and attorneys and leaders at the FTC with kind of making that combination for security and privacy enforcement.
If no one's ever told you this, Aaron, you're such a unicorn with that skill set, with the technical side of the what is actually happening, and then the legal side of what should be happening and trying to square that circle and make those two things make sense. So I'm curious, you've worked on some pretty high profile cases. I know I've talked about these, and so I'm super excited to hear what you have to say. So you've done things like Facebook's $5 billion settlements, how Amazon Alexa handles children's data, the Rite Aid facial recognition settlement. And I'd really like to know more about your role shaping the technical requirements of those settlements.
Yeah, yeah. So it's been in multiple different ways. So first, like it's been amazing, and I've had the great honor to work alongside some of the most keen and talented attorneys. It's really impressive to see FTC counsel work day in and day out for consumers, especially while taking on huge companies with many more resources, like Facebook, for instance. So in Facebook in particular, the FTC team was three attorneys and myself as the technologist. So it's a huge scaling difference versus a large company that happens. So okay, so for shaping the technical requirements, I've done a lot of work over the last like 4 years in particular on the FTC's approach to privacy and security settlements. So after the FTC has an investigation and decides to bring a case against a company around privacy and security issues, then traditionally after a privacy case, there's a negotiation between the FTC and the company, and that results in a settlement. And that settlement or that order is the legal requirements that the company then has to do moving forward. Um, Traditionally, these legal requirements have been you need to have a mandated security program or mandated privacy program, which is very much like a process-based thing that gives the company a lot of leeway to decide here are the particular risks that we're concerned with. Um, However, there's data that's so sensitive or high risk that it warrants enhanced protections. So one large part of my role was to help imagine and write and negotiate these brighter line rules. So practically speaking, this meant having a nuanced, like technical analysis of what the conduct that was unfair, figuring out like what legal language would go into orders or to negotiate that would address that problematic conduct, and then strike that balance of how do you prohibit unfair conduct, like a certain data sharing, while still allowing like beneficial data uses. Um,
Wow. Okay. So this is super fascinating. It actually leads me to my next question. You were talking about like sensitive data or special category data, depending on how you call that. Um, I'm curious about your thoughts on location data, particularly with connected car privacy issues, location data, data brokers. Can you shed some light on your work in that area and any big takeaways or lessons that you can share?
Yeah, so the FTC has had a number of cases against location data brokers over the last 3 or so years. So there's been X Mode, Gravy Analytics, In Market, Mobile Walla. Aspects of General Motors also touch on location data, and then Coachella, which is under active litigation. These cases, especially the finalized cases, so all the X Mode Gravy in market and mobile, they all have allegations where the FTC has said it's unfair for these companies to have either sat on a real-time bidding exchange and collected sensitive location data without people knowing and using it for other reasons, or to have unfairly shared or sold sensitive location data that is in on the facts of these cases has been here's a unique identifier that can be easily associated with an individual, and here's location data which is very precise, shows where someone was, shows a particular timestamp, and really is sensitive that could be used to like build a profile on someone or recognize like that this is where they are often. So the takeaway from those cases has really been that sort of conduct of like sharing and selling sensitive, precise location data is unfair. And for these particular companies, they're not allowed to do that from those bright line prohibitions from their settlements. And
Interesting.
there's also other, you mentioned location data in particular, but there's other categories of like sensitive or high risk data. So think health info, so like GoodRx, BetterHelp, Cerebral, browsing info, so Avast, and actually in the Avast order. If you read the definition of browsing info, it's very particular. It's very broad too. It says even a domain like LinkedIn.com is sensitive enough that deserves heightened protections. And then TV viewing in Visio, driver behavior data in GM, and then location data. So those are kind of the buckets right now.
Yeah, so this is so fascinating because what you're talking about is really like new types of technology, especially with the TV. I forgot the acronym, but when they take screenshots of what you're watching, or the location data that has both the timestamp and the location. And I believe I read something once that you only need four of those data points to uniquely identify someone 95% of the time. So my next question is something you touched on earlier, where you said you had a small team going up against these very well-resourced companies to try to figure out what's going on. So I'd like to know your advice that you might give to another regulator, maybe at a state level, on how they approach emerging technologies and emerging harms, especially as we're starting to get new regulations on data brokers in particularly and AI governance.
Yeah. I think emerging tech is one of those as an enforcer in the past, like has been a very like challenging area to kind of understand, what to do, what sort of actions to take, and so forth. I think the way I personally think about it is really where to find that balance between the opportunity for certain emerging tech to have like really societally enhancing innovations, things that will be helpful broadly to society and individuals, while also really being clear to those market participants, those organizations, like you need to actually manage the potential for a real risk of harm. And so on the harm side, like thinking through a lot of the fundamentals from FTC's cases, from privacy generally, is this emerging technology just like any other technology going to be something that has a real risk for potential harm? Are you taking steps to mitigate that and be deliberate about that before you deploy the technology? Are you constantly managing that and making sure that that risk of harm is reduced? And are you talking about it or informing like your consumers in a way that like is very clear and upfront and not surprising? So that's some of the contours. In terms of enforcers and legislators, I think like a lot of the remedies work that the FTC has done in the last 4 years, I think can be very well informed by for some of the new emerging legislation. Things like data retention requirements are things that are kind of fundamental, and data minimization are kind of fundamental to good security and privacy practices as a whole, and I think are can be a good, well-informed thing for any new sort of legislation that comes out addressing these like emerging tech issues.
Yeah, so that you actually raise an interesting point. For the businesses here, I'm curious, as a regulator, a former regulator, you've seen what good and bad looks like. So I'm curious about what advice you would give to a business on what you've seen companies, more broadly get right about their privacy and security programs to make sure they're in line with not promoting deceptive products or anti-competitive products. So, like, what would you advise a company from the start to make sure they don't end up in enforcement action?
Yeah, no, that's a really good question. In terms of takeaways for business, I think I can think of like three. I think first, like I think getting security and privacy right from the start is really critical. Like the privacy by design and security by design are like very important kind of first steps, and building that culture of security for an organization will go a long way toward like companies making informed choices around security and privacy that like actually engender trust in consumers. So they even little things for like startups, for instance, like getting multi-factor authentication from a security perspective, like implemented at the outset, can go a long ways. Like FTC has looked at traditionally like security and privacy from like a reasonableness standpoint and a consumer expectation standpoint, and what's uh, like clear and knowable to the consumer that they're expressly consenting to. So that can go a long way. So that's one. Um, Second, I think due diligence really matters, especially around marketing. One key FTC Act enforcement um, method is saying companies, you were being deceptive to consumers. So as privacy professionals or others, um, like being deliberate about making sure like the marketing material for a product or service is actually inaccurate, is actually substantiates like actually what you're doing is, I think, critical. Otherwise, putting out marketing material that's not accurate can lead to like a deceptive enforcement action. And then finally, a lot of these cases that I worked on or the FTC has done, really like at their base come from something that the consumer didn't know and was like totally largely separated from like what consumers reasonably expect. So unfairness from an FTC perspective includes like things that consumers can't reasonably avoid that don't have benefits. So like, would you expect your car manufacturer to gather exactly where you drive and how you drive your car, like hard braking or late night driving? Or would you expect your TV manufacturer to know what you're watching and then selling that data? Or would you expect an unknown company you don't interact with to have and sell your precise location data? So those in a lot of ways, that seems very intuitive. Like that's, you know, especially for high risk categories, making sure your consumers are really explicitly understanding and consenting to certain like collection use, and then you're not using that data for purposes like beyond what they know you're using it for and consented to for. So I think that's kind of the broad three takeaways for business.
Yeah. So my big takeaway there is make it reasonable and communicate clearly and make sure the reality of what you're doing actually matches what you're saying you're doing about it, would be a
Yes,
good first
you said
start.
it much faster than I can.
No, but we definitely need more collaboration with like the marketing teams and the technologists of like what's actually happening and how are we telling our consumers and giving them real choices on what it is that we're doing. So okay, I have one last question before we open it up to the audience, and that is if you could just please briefly tell us a little bit about what you're doing now and your new venture ahead of you.
Yeah, so I departed the FTC at the end of September formally, and I have been developing a new venture that I'm calling Alva Strategy Center, devoted to furthering security and privacy for all and enabling responsible AI innovation. In my soft launch phase, I've been largely word of mouth to date. So thank you for having this be a first opportunity to reach like a broader audience. I really appreciate it. So I think as part of this venture, I currently imagine three main things: expert consulting in context of like litigation or enforcement actions, aiding startups or pre-IPO companies on kind of what we talked about as developing those robust by design privacy and security and governance programs from the start. And then putting my attorney hat on, I'm also looking at providing strategic counsel on kind of some of the more vexing, challenging issues around privacy, security, or AI governance. And then as my venture grows, I dream of many other broader things that kind of fit that same vision of furthering security and privacy for everyone.
I love it. We'll have to have you back on the show once it gets to be humongous. Okay, so we'll go ahead and turn off the recording now and then open